As the Constitution bans government office holders from having dual citizenship before taking up legislative responsibility, Member of Parliament for Jomoro constituency Dorcas Tofe was dragged to court to prove denouncing her dual citizenship. Although the Member of Parliament has won the case, MP for Asin North, James Jachikwason, who is in court for a similar case, has been injuncted from holding himself as a lawmaker for his constituency. This report details more on the cases of MPs caught in this web.
The High Court on Monday, November 21, 2022, gave a verdict to the long-standing Jomoro election petition trial, an application filed by Joshua Emwa Kofi challenging the eligibility of the MP Dorcas Afotofe to contest as a representative of the people of Jomoro constituency on the ticket of the National Democratic Congress (NDC). According to the application, the MP, whilst contesting the election, was holding a dual citizenship, a Ghanaian and an Ivorian citizenship allegiance. Dorcas Afotofe, who was subsequently dragged to court for more than 2 years, was finally cleared on the grounds that, as at the time she won the 2020 elections as an MP, she had renounced her allegiance to Ivory Coast and, for that matter, remained a citizen of Ghana, hence her eligibility to occupy the seat as a lawmaker representing the people of Jomoro. Well, her fate has been determined, but James Jachikwason remains embattled in his quest to prove beyond reasonable doubt that he renounced his Canadian citizenship before contesting as a Member of Parliament for Asin North. The MP, who was dragged to court, has been injuncted by the Apex Court and is currently battling to overturn the decision not to have him represent the people of Asin North. Though his fate is yet to be reviewed and the outcome to be determined, the Asin North constituency seat remains vacant in Parliament, awaiting the decision of the Court of Appeal.
Let's have a conversation with legal practitioner Raphael Poku Eduse. Good afternoon to you, Raphael. As a legal practitioner, what do you make of the decision by the Second High Court on the case of the Jomoro MP?
Well, good afternoon. Good afternoon to your listeners. With a point of correction there, my name is Ralph Poku Eduse, not Raphael.
Thank you very much for the correction.
Right, having cleared that, the question again, please, if you may.
Yes, I was asking you as a legal practitioner, what do you make of what happened in court yesterday?
Okay, basically what happened in court, I think, is in consonance with the law. I've had the benefit of the judgment itself. I've looked at it. I've actually read it back to back, and then I will agree with the decision handed down or delivered by the court today. And this is for the following reason. When you take the petition that was actually sent to court, it was clear from the onset what the petitioner was looking for.
Right.
Specifically at, I think, the Relief 8, they were seeking a declaration, specifically for the court to declare that between the date of 5th of October to the 9th of October, the respondent was not eligible to contest for the elections, and they gave reasons that he held Ivorian and American citizenship at that material time. So what this does is that it puts just these two issues in issue for the court to determine. Now, when you look at the arguments and the evidence that were adduced so far, the court comes to the conclusion that at all material times, the case for the petitioner or the case of the petitioner was whether or not the respondent in this case indeed possessed the Ivorian or the American citizenship at the time of filing the nominations. And the court held that no, he didn't. And then the court based the reason for this decision on the fact that the Ivorian law was introduced at the trial, and an expert came and testified when the denunciation of citizenship or Ivorian citizenship for that matter is effected. And the court agreed with it, with the fact that the Ivorian expert who came and testified had actually indicated that upon filing the form to denounce your citizenship, that is the effective date of your denunciation, and therefore held that at the time of the elections or between the dates aforesaid, the respondent did not, as it is, hold any Ivorian or American citizenship.
Right, right. Now,
So
Mr. Ralph,
basically,
yes.
this is the
Right.
the rationale behind the decision of the court yesterday.
Right, right. Mr. Ralph, Pokwe say, but what precedent does the ruling have on the subsequent cases?
It will not have any precedent. Let me be clear on this.
Right.
You see, the case after case, evidence are different. This is a case that, in the case of the question, clearly the court established for a fact that between the 5th and 9th of October 2020, the respondent in that case had not renounced his citizenship with the Canadian authorities.
Right.
So, where in this case, the court has found for a fact that the respondent in this case, clearly by reason of the Ivorian laws, she has actually denounced her citizenship, then clearly there are two different cases that you can't say because this one has succeeded, the crazy matter should also succeed. I believe that, or I think that the crazy matter is that he can't, as it is, make any argument that would change the fact that when we consider the applicable laws, which in his case would be that of the Canadian law and the Ghana law, you can make a comparison that this one has succeeded and therefore he should succeed. I don't think it will follow in that manner.
Right, right. Ralph.
But there's one point I want to make clear.
Right.
Let me clear something on the decision that was handed down yesterday. You realize that there's a contention that the petitioner, that's the counsel for the petitioners, are arguing that there were some arguments on fraud that the court has failed to consider. And this has to do with the Ghanaian citizenship of the respondent. Clearly, there was an opportunity, if they wanted to make that argument, to have amended their pleadings or the petition to include these particulars of the fraud allegation that they are making. And that would have allowed the court to set that issue where the issue concerning her Ghanaian nationality is put in issue. The court would therefore be able to consider it. Since that was not done, you can't, as it is, expect the court to substitute that case for the case that you presented and make a determination that by reason of that, she is not fit or she should be declared, unfit to hold herself out as a member of parliament duly elected. I think that essentially, if they wanted to make the argument
we're
that
running out of time, so if you can be brief, I'd very much appreciate it, Mr. Pokwe say.
So what I would therefore suggest is that, yes, this is, it has come as a good piece of education to all of us. Let us understand what you have to do when you want to challenge the elections in future. And let us all be guided by this decision, because I've had the benefit of the decision, and I think it's on point.
Right. Ralph Pokwe is a legal practitioner. Thank you very much indeed.